Good afternoon, everyone. Welcome to the District of Columbia Court of Appeals. We're going to hear the case of Timothy Gibson versus United States, 18 CO 1105. The case is here on cross motions for summary relief. It's an appeal from an order of pretrial detention, and the panel decided that oral argument might be helpful. So let's see if it is.
Good afternoon, and may it please the court. Joshua Deal on behalf of appellant Timothy Gibson. I'd like to reserve 2 minutes for rebuttal. The trial court committed two independent legal errors in ordering Mr. Gibson detained under Section 1325. First, while it correctly held that there was adequate provocation to reduce any murder to manslaughter, where Mr. Gibson was ambushed, dragged from a car, punched in the face, slammed on the pavement like a pretzel, and then his companion was issued a death threat, it incorrectly found that the time it took him to grab a gun and fire it was a sufficient cooling off period for there to be probable cause that he was not acting in the ensuing rage or fear that that adequate provocation caused. It is inconceivable, as a matter of fact, that a person subjected to such a brutal beating and death threat could have cooled down in the span of a few seconds. And the trial court's contrary finding, was based on an error of law, erroneously conflating the amount of time it takes to form an intent to kill with the necessarily longer amount of time it takes to do so calmly and with composure and for the provocation to wear off. And
when the trial court found that he was not acting in response to adequate provocation, do you think she meant that to apply to the first two shots or to the third shot, which occurred somewhat later?
I'm not sure, Judge Fisher. I think probably more to the third shot because she at least put some emphasis on W2's statement that he had turned back toward Mr. Baker and fired a final shot. But I don't think it matters. The amount of time, the evidence is that these were 10 rapid fire shots that occurred. There is no evidence, despite multiple government witnesses on the scene, that there was a pause in the shooting or that he took a break.
Well, there had to be some pause between the shots that were fired, one of which felled the decedent, and then the steps that were the steps that were necessary, physical steps that were necessary to bring your client closer to the decedent and then fire again. So there has to be some break in that action.
That's not right, Judge McLeese, because it's based on an inaccurate factual premise. So, and this is something we tried to dispel in our reply brief. There is a single statement where the officer is asked whether or not Mr. Gibson was walking toward Baker and his brother while he was shooting these shots. And he said that's the way W2 made it seem. That's the only evidence we have of Mr. Gibson approaching Mr. Baker while he was on the ground. It's that he was approaching while he was firing all 10 of the shots. There was no evidence that there was a break in the shooting. There was no evidence that he walked right up to Mr. Baker and shot him in the head. The only thing we have is he's walking toward him as he's shooting. The only...
I thought there was evidence that the victim was in death throes on the ground. It was wiggling and jiggling, or whatever the word was.
That's correct, Judge Nebeker. W2 said that he might have been wiggling on the ground. He wasn't even clear on that, though. It might have been that the first shot was the fatal one. The government didn't put on any testimony as to which of the two shots were fatal. However, we don't
Just to make sure I understand, the trial court, I thought, made a contrary factual finding. The trial court said, described things as, while the decedent was on the ground, appellant went over and shot him in the head.
Yeah, so
in your view, that's a clearly erroneous factual finding?
That's clearly erroneous if you interpret it the way the government interprets it, or the way your question has framed it, which is that he walks up to him and shoots him from point-blank range. That would be clearly erroneous. I think there is an interpretation, which is what she says on the prior page, which is that he's moving closer while he's shooting. It's not a break in time. It's not like Williams, where you have a series of shots, the person is felled, and then you have somebody who calmly and collectively walks over and shoots them. This is a rapid-fire series of shots. And I just want to stress, the government has shot spotter recordings of these shots. It has W1 and W2 on the scene, who are ear witnesses. W2 is an eyewitness as well. And it has an officer in the area. Not one iota of evidence that there is any sort of pause in the shooting, and that includes the defense witnesses as well. Nobody testifies to anything like that. What you have, I mean, it is, so I think the charitable view of the trial court's ruling is they're not that far apart to begin with. Remember, we're talking about about a lane of a street. So call it 15 feet, a few strides is how we described it. The government described it as out of arm's reach. So moving closer, I mean, it is pretty close, but it is not necessary to take a pause to move closer to somebody from that distance.
Isn't there something in the record having to do with the shot reports being recorded?
Yes, there is.
Were they played?
No, they weren't. The prosecutor asked the officer whether or not they had shot spotter recordings, and he said yes. And she said, have you listened to them? And he said no. She asked, did you ask the officer who was on the scene, did he hear any break in the shooting? And he said no. Was there any break in the shooting? And this is all, if you, court's indulgence for a second, I believe I have a citation for it here, otherwise I can find it before the rebuttal. You know, I don't see it here right now, but it should be at some point in the September 14th hearing, where they're asked, and they just don't have any evidence that there's a pause in the shooting. And
Can I ask you a question? You were distinguishing between the circumstances that might permit a conclusion of intent to kill and the circumstances that might support a conclusion of the ending of heat of passion. Do you dispute on this record that a trial court could find that your client acted with an intent to kill?
no. No, we don't make that dispute. We don't dispute that. I mean, we haven't disputed probable cause for voluntary manslaughter. I mean,
Understood, or substantial, I mean, you really didn't dispute that your client acted with an intent to kill?
oh, I mean, that, not before the trial court.
For purposes of this hearing and the
That's
detention
right.
determination.
That's right. I mean, but again, you know, as this court said in Comer, what voluntary manslaughter is it's a killing committed with a design to kill under the influence of a sudden and violent passion caused by great provocation. This is the definition of that.
Understood, but the reason I was asking that question, I'm puzzled by an aspect of this case. Because statutorily, under 1325, assault with intent to kill while armed itself triggers a rebuttable presumption. And if there is no dispute, for purposes of the detention hearing, that your client at least committed assault with intent to kill while armed, as to which heat of passion caused by adequate provocation is in the defense, it's just puzzling to me why, as a matter of law, the statutory presumption isn't triggered.
I could understand that. I think it's just because it's not an argument that was made below. The government never made an argument that it was assault with intent to kill. Perhaps we would have challenged that. I mean, the government does say in its arguments that these are wild and erratic shootings, that, you know, Mr. Gibson misses 7 of them and that he's sort of flailing as he's shooting and he hits a nearby car. So they could have challenged the intent to kill aspect of this, but I mean, I think defense counsel didn't, because this looks an awful lot like a voluntary manslaughter, at least for purposes of a probable cause finding, and the government wasn't asking for a hold.
Can I ask you a related question? I understood your filings in this court to suggest that you were drawing a distinction not only between intent to kill as a mental state and heat of passion as a mental state, but also premeditation and deliberation as a mental state. And we're suggesting that it may be easier to premeditate and deliberate than to cool down. Am I right in understanding your brief is attempting to draw that distinction? Or your filings in this court?
I believe that's right. I mean, what this court said, what this court has referred to it in Brown, it referred to it as, you know, this is Brown versus United States, 584 A2D 537, it's a note 15, that it needs to be under cool reflection. And once you have that provocation, the coolness has been stripped from it. The notion that somebody, it's not just that you are reflecting, but if you do so, and again, this goes back to the Comer definition that we already cited. I mean, there is a design to kill under voluntary manslaughter. It's just whether or not somebody could do so with a calm mind. And
I'm just on the distinction between heat of passion and premeditation deliberation and the suggestion that maybe someone could have premeditated and deliberated but still be acting in the heat of passion. That seems to be contrary to things we've said and would have some strange consequences about what would be greaters and lessers of first-degree murder and second-degree murder and the like. So it seems puzzling.
Yeah, no, I understand the concern, and perhaps I've misstated it slightly. I do think that would be a little bit puzzling. I think my point is that that form of premeditation, if you're talking about calm reflection, the way that premeditation requires, is not available when somebody has been adequately provoked until there's been some cooling off period first. So all I meant to say is...
I mean, to the extent we've said that no particular amount of time is necessary for there to be premeditation and deliberation, And if premeditation and deliberation is inconsistent with heat of passion, as some of our cases seem to say, then it seems to follow by a chain of reasoning that no particular amount of time is required for heat of passion to ebb.
I disagree with that chain of reasoning, Judge McLeese, and here's why. I mean, I think it's one thing to say a person who is calm and cool, you know, in this moment, could form a premeditation to commit murder in the span of a few seconds. I think it is quite another, and something that no court has ever said in any case that I'm aware of, that the government has pointed to, that a person who has been subjected to this level of a violent beating could undertake that same sort of premeditation, that calm and cool deliberation that's going to take, it might take a few seconds when somebody's starting off calm and cool, but you need to allow time for the provocation to dissipate first. And, you know, we cited corpus juris secundum to say, you know, courts have found that it's inadequate cooling off period if it's 1, 2 minutes, 15 minutes, and then if you get longer than 15 minutes, they start to say, okay, that's long enough. But this is classic voluntary manslaughter in that it's immediately upon a sudden affray. And trying to suss out 1, 2, 3 seconds, that's not gonna cut it when you're talking about this level of violent provocation. And I wanna stress how violent it is to pick somebody off the ground and flatten them like a pretzel, body slam them on the street. I don't think the Dalai Lama is going to be calm and cool in the few seconds after that. Nobody could be.
Though one would hope the Dalai Lama might not shoot people who are fleeing and then continue to shoot someone who is moving on the ground in the back of the head.
That's right. We would hope that he wouldn't have a design to kill, which is not disputed here, and that's why, you know, we're not disputing that this is a very serious charge of voluntary manslaughter that Mr. Gibson could be held on. What we're disputing is that you can't hold him for committing that under a calm and cool mind after he got ambushed by 2 men and beaten so violently while a loved one was issued a death threat.
Mr. Deal, I'm not sure you've had a chance to identify the second error.
Thank you, Judge.
And in the interest of helping us decide how to spend our time asking questions, would you at least identify it?
Of course. That the trial court violated this court's ruling in Pope that when there's mere probable cause to believe a defendant has committed a second-degree murder while armed, the government's burden to prove by clear and convincing evidence that the defendant is properly subject to preventive detention cannot be satisfied simply by reference to the known facts of the crime.
Well, let me ask you about that. Maybe we've read Pope pretty broadly, but the logic of Pope makes most sense to me in light of the facts of Pope. It was a case of alleged misidentification. There was barely probable cause to think that Mr. Pope was the culprit. And I understand when that is the issue on probable cause, it's hard to figure out how you can turn the facts of the offense into clear and convincing evidence of dangerousness.
Right.
Here there is no dispute for present purposes about your clients having fired the gun and having done so in a pretty dangerous way. And I'm wondering if it's fair to apply Pope to this situation.
I think it is, Judge Fisher. I don't think that Pope's ruling is fact-bound. It makes a very clear statutory ruling, which is that the legislature, when they codified Section 1325, said there needs to be substantial, in order to invoke a presumption that an individual is dangerous, there needs to be substantial probability that he committed the crime and that he did so while armed. Both of those factors need to be present.
Let's assume for present purposes, I'm not talking about a rebuttable presumption.
Okay.
But if you're trying to figure out, without the benefit of a presumption, whether there's adequate evidence of dangerousness, is it fair to restrict or fair to preclude the court from considering the facts of the crime?
It's not that the court's precluded from doing it. It's that the legislature has already assumed by finding that there is no rebuttable presumption in favor of detention, effectively that there's a presumption in favor of liberty, they're already assuming a dangerous crime like a murder. They're already assuming the individual has committed the offense while armed. Those things have been found beyond probable cause, and they still favor liberty, and they say you need to look at all the other factors in Section 1322 to determine whether or not this individual can be held. And each of those 4 factors strongly favor Mr. Gibson in this case. The factors are the heinousness of the offense as compared to other murders. And whatever you might say about this offense, it is a rare defendant that has really been dragged into this against his will, that got dragged out of a car that he was trying to stay into. He didn't come out of that car with a gun. He was dragged out of it, and then after he got slammed on the pavement, he grabbed one. The other factors include, was he on probation or parole? He wasn't. Does he have any criminal history? No. In 27 years, he has not a single conviction. And and I apologize, I'm missing one factor. The particular threat he posed, and the only threat that the trial court articulates here that Mr. Gibson poses was based on some entirely nebulous reference to some disturbances in the courtroom. There was not some identified and articulable threat he posed to an individual or the community beyond that. So I think
The court also emphasized future access to firearms. What does the record show about whether this firearm was recovered on the scene?
there's no evidence of that, Judge Fisher.
It's identified as a Luger, isn't it? 9 millimeter Luger?
I think that's, I don't recall, Judge Nebeker. That might be right.
Well, the question that I would then pose is whether the shooting had to be interrupted while he ejected a magazine and installed another one. In other words, did he have 12, 14 rounds in a magazine? In a handgun? I don't know.
Well, Judge Nebeker, I mean, the evidence was that there were 10 shots fired. There were 10 shots fired?
Yeah, well, there are 10 shots. Weren't they the random shots as distinguished from the ones that killed the victim?
I believe that the evidence can only support that there are 10 rapid fire shots. You know, they have witnesses on the scene, including Mr. Baker's brother, who says he turns around when the shots stop and he sees Mr. Gibson standing there with a gun. There's nothing that happens after the pause in shooting. I mean, I think that's critical on the voluntary manslaughter issue that we've been discussing. There's not evidence that he reloaded the gun. The government never suggested that he reloaded the gun. There's no evidence that there was a pause in the shooting in any way. This is nothing but, you know, it is a classic heat of passion voluntary manslaughter type of case, if not perfect self-defense, given the degree of physicality and the death threat that was issued right before it.
Do you think the evidence in this case would be adequate to support a hold under 1322?
We argue in our brief that it's not, that even if you look at 1322 and you consider a rebuttable presumption of dangerousness, what you have here is you go back to the same factors that 1322 mandates. You look at criminal history, you look, does he have any substance abuse problems? No, he doesn't. Does he have any criminal history? No, he's a law-abiding person. He's not on probation or parole. There is no real identified danger that he poses to anybody other than disturbances in the courtroom. They all factor on his side. I mean, I do think that it's a closer question. Obviously, there's a thumb on the scale in favor of detention once you have that rebuttable presumption. We wouldn't oppose.
For present purposes, I'd like you to forget a rebuttable presumption. One can find clear and convincing evidence without a presumption.
Sure.
And why couldn't you find dangerousness on this record?
I think because Pope says you can't do it with mere reference to the facts of the case because the legislature has said that's not enough.
Assume for a moment that Pope didn't exist and we weren't bound by it, which is obviously not the case, but do you think there's some, in a case where the offense, a single offense is so outrageous and disturbing in the manner of its commission, it's always illogical or unreasonable for someone who was unconstrained by Pope to say, well, I find probable cause to believe that this offense occurred, and let's say I find by more than probable cause that some very disturbing aspects of it occurred, and therefore I'm going to find by clear and convincing evidence the person is dangerous. Is that like somehow conceptually flawed intrinsically, or is it just that you think it's more a statutory interpretation, set of policy determinations that overlay what might be in, you know, isolation, pristine logic?
I mean, I don't think there's a logical flaw in that. I think it's primarily a statutory interpretation argument, of course, with the backdrop of constitutional concerns that, you know, the court laid out in Salerno, that we're talking about an indefinite hold here. Somebody who is, if this 1325 hold is going to be put on Mr. Gibson, he's going to be in prison for some number of years. I mean, there's a tentative trial date set for September of 2019 right now.
Can I move back to a more abstract legal question again
Sure.
about how broadly or narrowly Pope should be understood? The phrase, I think, in Pope about what is, at least in the context of Pope, inadequate by itself to support a conclusion of dangerousness are the known facts of the crime. I find it a little hard to know what things are so tied in with the crime to be the facts of the crime and what things start getting further away. And the trial court thought that your client's coming to the scene aware of the location of a gun and access to a gun wasn't really barred by Pope because it wasn't a known fact regarding the crime, or if I'm remembering the phrase in Pope right. But it just doesn't seem very clear what
Sure.
connection there needs to be between a circumstance and the facts of the crime to run afoul of Pope if it's applicable or not. Do you have any guidance about what you think are the known facts of a crime?
I don't know if I have any guidance on the abstract principle, but maybe a little bit on the facts of this crime, which is that the trial court didn't find that Mr. Gibson arrived on the scene or that he brought a gun or that this was his gun. It said quite the opposite. It said,
I thought the trial court inferred that your client was aware of the gun at the time your client arrived on the scene.
I don't think that's part of the trial court's finding, but I mean, if you're talking about the few minutes earlier that he shows up, that might be fair. I mean, that to me, that strikes me as a fair enough inference, although I don't think it's inescapable from the record. Remember, this is his ex-girlfriend's car, not his. The gun is in her car, not on his person, and there's no evidence that the evidence is pretty clear they didn't go anywhere to get it. The evidence is that after they left Mr. Gibson's sister's house that she had just been dragged and beaten out of by Mr. Baker, they went to the 7-Eleven, which is where they got a call, which is just a block from where they met the decedent. It's all in this really small 3-block radius where people are going. So I think the most you could infer is that his ex-girlfriend had a gun in the car, and maybe while he's getting beaten, maybe moments before, she lets him know these guys are dangerous to let you know there's a gun here as well if you need it. Because, of course, we know that Mr. Baker tends to be armed, which is evidence from both W5 and W6, the girlfriend and the sister.
Let me ask you a hypothetical. Just imagine that after the shooting and on the scene, there was evidence that your client said, I wish I had killed all of that family.
Yeah, sure.
Would that be, in your view, one of the known facts and circumstances of the crime, and therefore a trial court who found for sure that happened? I have concerns about heat of passion caused by adequate provocation, so I don't find murder too while armed by a substantial probability. But for sure, I heard that I believe would be foreclosed from detaining your client because it's kind of bootstrapping that's foreclosed by Pope.
I don't have a problem with that either. I mean, especially if there's some break in time. I mean, if we're still talking about where that would be a credible thing that he would act on when not enraged after a violent beating like that, I would say, of course. I mean, if it happened the next day, especially if it were a more explicit threat, I'm looking to finish the job. I think that would clearly be an additional fact that the court could look at.
That wouldn't be a known fact regarding the crime.
It would not be a known fact regarding the crime.
The trial court, as I understood it, was also motivated by her perception that these two families hate each other, and there's likely to be violence if your client is released, and one of her premises is he knows where to get a gun when he wants one. What's wrong with that reasoning?
I think it's wrong at every single step, Judge Fischer. So let's start with the first step. These families are extremely close. Mr. Gibson's sister has been dating the deceased Mr. Baker for 7 years. They have a kid together. Mr. Gibson used to live with them. That's all in the record.
Families that once were close
Sure.
can grow to hate each other.
With Thanksgiving coming up, Judge Fischer, I'm sure we're all about to be reminded of that. But the evidence of that is not in the record. I mean, what we have is the judge saying twice, could you please keep it down in the courtroom? And also, there's something at the end of the September 14th transcript.
Well, part of the evidence is a member of one family killed a member of the other family. Now, there's an obvious motive for hatred.
That's true, Judge Fischer. That's true in every murder. I mean, Pope addressed that as well. It said, when these things happen, letting somebody out, somebody who's believed to be the killer of somebody, that's going to cause some acrimony, some fear, probably some rage in the family of the deceased. But that's not enough to hold somebody. That is not an identified and articulable threat That's just something that occurs whenever there's a murder charge. And remember, after the September 14th hearing, there's not another disturbance on the record for over a month. And it behooves me to mention that on September 20th, before the halfway house rejected him based on a policy that doesn't really exist, Judge Dason found that pretrial detention is inappropriate when she weighed all of the appropriate factors. And it was only, some weeks later that she said, well, I guess if the halfway house isn't available, then I'll have to send him to the jail. And she doesn't really articulate why, and this goes back to your earlier question about why I think it's wrong on every step. She could have put him on house arrest that would have been further outside of the community than where the halfway house was. She could have put him on GPS monitoring in a way that made sure he didn't even get anywhere near that neighborhood. In fact, Mr. Gibson said you can send him to Maryland and keep a stay away on DC entirely. And she never articulated why that wasn't good enough. And the notion that he knows how to get a gun, I mean, if that's enough, then that's true. That's just true of every single 1325 case, that somebody knew how to get a gun, otherwise they wouldn't be there on a wall-arm defense. So if this court said that, it would just be upending the statutory presumption.
One of the cases that I found very thought-provoking was Jones. And part of Jones says you got to keep in mind that a finding of clear and convincing evidence of dangerousness is a cumulative judgment that does not depend solely upon a probable cause finding.
Correct.
There's a wide range of things you can look at. And as I recall, Jones was decided before Pope. But your argument seems to say, relying on Pope, that the finding of probable cause essentially precludes a finding of dangerousness based on the truly violent facts of this case.
No, of course not. I mean, I hope I haven't said anything like that. A finding of mere probable cause, of course the government can still show clear and convincing evidence of dangerousness if they have somebody who has, a history of dangerousness, if you have somebody who has past convictions on their record, if you have somebody who has a gang affiliation, or somebody who's continuing to make threats after the charge.
Jones focused on the horrible treatment given to the young child in that case.
Right.
And there's a footnote that says something like, if there were evidence of torture, we wouldn't hesitate to find dangerousness based solely on the facts of the case.
That's right.
And why isn't that like this case?
I mean, my reaction is a little bit shocked, Judge Fisher, because I think this is, if you're talking about, the mine run of murders, which, as Pope recognizes, is usually a horrific set of facts on its own. And torture is way out here to one end on being particularly heinous and egregious. This case here is way out on the other end. This isn't somebody who showed up looking for a fight. The fight came to him. He got dragged out of a car, and it really looks a lot like a self-defense case, Judge Fisher. I don't think...
Well, that may run a bit far if the shots that are fired while the two victims are running, and then a subsequent shot is to the back of the head of a victim who is wriggling on the ground. I don't know that so much cries out as a self-defense case.
I don't know, Judge McLeese. I mean, I disagree a little bit. The government really stresses that they had turned their backs. Remember, this is immediately after he issues a death threat to Mr. Baker's girlfriend, ex-girlfriend. He issues a death threat to her, turns around. There's no reason why after a violent beating and death threat like that, a person in Mr. Gibson's position is going to think a turn of the back means you're no longer in trouble. I mean, the Supreme Court in Justice Holmes' opinion in Brown, which we cite in our case, that's talking about a final shot to somebody who's down, and Justice Holmes says that's still enough for self-defense because you can't expect somebody in that situation to be thinking as clear-headedly as all of us sitting here in a courtroom today. For all he knew, he was turning around so he could conceal the fact that he was grabbing a gun out of his pouch, which there is some record to support. Remember, that pouch has guns and a digital scale in it. He's known to carry a gun in it, which is evidence in the record as well. And so he might think what's happening right now is not that these guys are running away from me. Maybe they're running for cover to get a gun. Maybe they're running to their own car to get a gun. But I mean, I don't want to fight you on that point too much.
Fair enough. Let me just, I had another abstract question about how you think Pope operates.
Uh-huh.
So would this have been an appropriate way for the trial court to look at this? I'm not saying this is exactly the way the trial court did, but if the trial court had said, I find that this is really dangerous conduct, even if I am willing to view as mitigating the prior circumstances, which I think you'd have to view as to a degree mitigating. Still, at the end of the day, he's firing off multiple rounds in a public area and then walks over. That's not right. Then continues to move towards someone and shoot someone in the back of the head. That's really dangerous conduct. Now, I know from Pope that I can't rely solely on that. But, so that means that I can rely on that for 99% of what I need, and really, I don't need much more. If there's anything more, I'm going to hold this defendant consistent with Pope. Is that a permissible way of looking at things, or do you think that Pope really means that you can't treat the circumstance? I mean, I assume you don't think the circumstances that have to be treated as irrelevant.
Correct.
So they can be treated as highly relevant, but not by themselves enough.
Of course, it could be highly relevant. I might disagree a little bit with that. You just need 1% more. But maybe I'd put it at 40% more. But regardless, there's no more here. The additional thing that she cites to was audience disruptions in the courtroom. And remember, on September 20th, that wasn't enough for her to order a pretrial hold. The only additional thing that entered the calculus was his access to a firearm, which we argue is inextricable from the wall-arm defense. And it's true in every single murder, and every wall-arm defense, that somebody has some fleeting access to the firearms. And Mr. Gibson's was less than most of them, because there's no evidence that he got it from a house earlier that day. There's no evidence that it wasn't his ex-girlfriend's who was driving the car, which is where he found the gun.
I know you're over time, and I'm going back to your first point.
Sure.
But I know that in its filings, the government relied on the question, with respect to the first issue, the question of whether the trial court had an adequate basis to find probable cause to believe there was second-degree murder, as against your claim of heat of passion. They relied on the Williams case. And it's not something that you've had addressed yet extensively in your writings, but there's a sentence in there that I'm interested in your response to in particular. Yeah, I imagine you could foresee it. And again, this is in the setting, although it's distinguishable in a bunch of ways from this case, it is in a setting where the defendant in Williams' shooting of the victim occurs after the victim has been shooting at the defendant, if I recall right. And the court says, appellant's action in moving closer to his victim and the time that it took, although ever so brief, is sufficient for a reasonable juror to find that he considered and reflected upon his actions. How do you square that with a view that sort of as a matter of law, the trial court here couldn't find probable cause, at least, to believe that the time when your client moved closer to his victim, though ever so brief, was sufficient to permit a conclusion that your client considered and reflected?
The big distinction, Judge McLeese, is that there's nowhere near the provocation. I mean, in Williams, the court finds that there is no provocation. That's the first step. So it might be that those few seconds are enough time to premeditate and reflect for somebody who's acting with a cool mind. And I think in Williams' case, you have a defendant who is acting with a cool mind, who appears to be in control of the situation. He starts the fight.
Well, I mean, he was shot at, so I would think that would tend to make you lose your cool.
He wasn't shot at. Okay, could you point? I remember brandishing a gun. I know you were on the case, Judge McLeese. So
no, I may be mischaracterizing things. So,
my memory, and I think you worked on the case, so I might defer to yours.
Don't defer to me, please.
My memory is that Mr. Williams had walked up and pushed the other individual, at which point he brandished a gun and the other person did likewise, and then reached for it and never got it out of his waistband.
Okay. Well, yeah, so I mean, again, the facts are somewhat murky, so I'm not sure we'll be able to sort this out here, but okay. At least there was evidence in Williams that the decedent spinned around and pulled his gun and started firing at me. This is the defense testimony. And so the way I read the passage I was discussing was kind of on the assumption that there had been shots fired by the decedent at the defendant, which was disputed factually, I think. And then the court said, but in any event, the time of walking was enough. So that's as I recall. But I may well be mistaken.
Yes,
so
I mean, I don't
defer to me.
That was the defendant's testimony, which my memory of Williams was basically just roundly rejected by the court. It said we have his girlfriend at the time and her brother, who are both on the scene, who say otherwise. And of course, Williams itself was a voluntary manslaughter case. I mean, that's where he was convicted. I understand that the court had to address whether or not instructions on first and second degree murder were appropriate. But when it gets to the provocation part of its discussion, the court says, you know, what you have there is the defendant is the first one to push and he's the first one to draw a gun. And they say, you know, whether or not somebody brandishing a gun might keep you in fear, once you've felled them and they're down and they don't have a gun, that fear might be able to dissipate in the time it takes to walk over to somebody, stand over them, and say, now you're going to die. You know, very different facts from this case, because we're not just talking about fear here, we're talking about rage from a very violent beating, and we're not talking about somebody who walks up and lords over somebody and says something. We're talking about rapid fire shots, and I understand that there seems to be some pushback on that. You know, all I can say is the government had an opportunity to ask any of its witnesses whether or not there was a break in the fire. They had an opportunity to put on a shot spotter, had an opportunity to call the officer or just ask the officer through a hearsay witness whether or not there was a break in the shots fired, and there's not a modicum of evidence on that.
Mr. Deal, let's give you a break and hear from Mr. Smith.
Thank you very much.
May it please the court, Peter Smith on behalf of the United States. This court should affirm the trial court's order of detention. The trial court made a factual finding that appellant was not acting pursuant to the provocation at the time of the shooting. And the trial court had several—
I'm not sure that's quite right. I think the trial court found that there was at least probable cause to believe that was true. I don't know if the trial court found it as a matter of fact.
You're saying probable cause to believe that appellant wasn't acting was basically had cooled off or wasn't acting under provocation.
I mean, I don't think the trial court was finding that by preponderance. I think the trial court said, I find that the government has introduced evidence that is sufficient to establish probable cause on that point, and therefore I conduct the rest of my analysis on that predicate.
I would agree with that. I guess I'm saying that I guess what I'm trying to say is that there are predicate factual findings that led to that conclusion. And the factual findings were, she cited at least 4 things. They are retrieving a gun from the car, moving closer, which the court discussed earlier, shooting the victim as they were walking or running away, shooting at the fleeing victim, and shooting the victim in the head. She thought that each of those things indicated that appellant was acting with reflection and not without reflection, which is the requirement for mitigation.
Let me follow up by asking the question I tried to ask Mr. Deal. Do you think her finding that Mr. Gibson was not acting in response to provocation included all 3 shots, or did it distinguish between the first 2 and the shot to the back of the head?
I think it included all of them, but she did say that something like at least by the time that appellant shot Baker in the head, then he was acting reflectively. But I think that that statement includes all of the shots, that he was acting reflectively, because some of the other factors I just mentioned happened before the shooting even began, like going to get the gun from the car. But her conclusion was certainly that by the time that appellant shot the victim in the head when he was lying prone on the ground, that he was at that point acting reflectively.
All of those circumstances seem very tightly tied in time and place to the commission of the offense. And so what's your view about why it would be fair to say that they are not known facts regarding the crime and therefore subject to the limitations that Pope announces, assuming for a moment that there isn't some other distinction between our situation and Pope?
Well, I think some of them would fall under Pope's holding, being the circumstances of the offense, like the manner of the shooting itself, like the shooting in the head, is similar to Pope. In Pope, it was the viciousness of the shooting of the victim who was hiding underneath the car that drove this court's holding, and that was dispositive for the trial court. It was the reason for the hold in Pope. So I think that the court, that outside of Pope could include, and maybe I'm going beyond your question, Judge McLeese, but beyond the Pope holding would be factors here, like the fact that appellant entered Baker's house before the shooting and searching for Baker and confronted the people inside the house, appellants driving around with a gun in the car. Things like that certainly wouldn't fall under the holding of Pope.
Why do you say that? To me, the phrase known circumstances of the crime is anything but clear. That also, I mean, if somebody said, tell me the story of the crime, you'd probably start with that. It's not something that's extrinsic to the crime. So it's just not clear to me that that's outside the rule announced in Pope, any of that.
Well, I think that those things would be outside the rule in Pope, because Pope isn't saying, you know, tell me the story of the crime. It's saying, when it's talking about the circumstances of the offense, it's very fact-intensive. It was driven by the fact that the trial court's decision in Pope was driven by the fact that it was a vicious shooting and the fact that the victim was hiding underneath the car. And that was the main reason the trial court held the defendant in that case. And that was the reason. So I think that you have, when you consider Pope's holding, you have to be looking at those facts, and that the court can consider other things. And that seems like a sensible rule, because if you don't have that sort of rule, then you can't look at things that happened, say, earlier in the day of a murder or the day before a murder. You can say all those things are part of the story of the murder. Here you have the trial court looking at other factors, like the sort of feud between the families. And I would say that doesn't fall under Pope's holding. There are a lot of elements that the trial court looked to that don't fall under, you know, what we would call, for the sake of convenience now, is the Pope rule.
You spoke a minute ago about driving around ahead of time with a gun in the car. What is the evidence that he knew at that time that there was a gun in the car?
Well, appellant is driving the car. The gun is clearly in the car because...
It's not his, is it?
I don't think so. The trial court couldn't say that she couldn't conclude that it was his, but he knew exactly where it was. He was able to get it very quickly. There was also loose ammunition in the car. The government's pleading cites that the record citation for the fact that there was ammunition found in the car later. Appellant knows exactly where it is. He's able to get the gun quickly, and there's no indication.
Focusing on that element, the idea that as one of the additional circumstances that Pope doesn't prohibit a trial judge from relying upon to find someone dangerous, even though with respect to some narrowly defined view of the circumstances of the offense, the trial court only finds probable cause. Your opponent argues, I think, roughly, that if that's a permissible way of responding to Pope, that really a lot of the logic of Pope is undermined, because in many, many murders, who knows what percentage, but in the typical murder, the defendant will have had access to or knowledge of or awareness of a gun beforehand. It's probably the unusual murder where the defendant somehow grabs an instrumentality and kills somebody, or pulls it away from, or is handed it from somewhere. So most murders are going to be like that. And if that's the way Pope functions, then what would happen is a trial court finds probable cause to believe there's a murder, says, well, this is like almost all other murders. The defendant had access to a weapon ahead of time. That makes him dangerous. Therefore, I'm going to have a 1325 hold, even though 1325, by its statutory structure, seems to say that the run-of-the-mill secondary murder, if all there is probable cause to believe it, isn't a basis for a hold. And so it seems like a relatively easy end run around the concerns that animated Pope. What's your response to that paraphrase, or effort to paraphrase your opponent's argument?
Perhaps, I mean, I guess it's true that any well-armed defense is going to involve the use of an arm, but what's different between this case and Pope would be the fact that appellant was driving around in the car prior to the crime with the gun. So you have...
If I go to a rendezvous with an enemy and I'm walking around with a gun in my waistband, does that mean that Pope doesn't apply to my possession of the gun ahead of time?
Well, I think walking around with the gun in your waistband is an indication that you carry a gun or own a gun or have a gun. That's more than simply access to a gun. And I guess the case itself doesn't indicate how the defendant got the gun in that case, but there are certainly cases where somebody either finds or obtains a gun at the crime scene or is given a gun at the crime scene.
And in fact, this case is weaker than the average murder, I would say. I mean, I don't have a good empirical basis for this, but my impression is it's probably on the weaker side of murder with respect to the evidence of the defendant's prior possession of or access to a gun. Because all the direct evidence is that, I mean, I think it's a fair inference that he had some knowledge ahead of the incident that there was a gun in the car and where it was, because he got it very quickly under adverse conditions, which supports a reasonable inference that that was true. But there's, I mean, it's not, I mean, I would bet most murders there's stronger evidence of a connection to a gun than there is here. Or I mean, guns aren't the only weapons used in murder, but, and not all weapons involve, not all murders involve weapons either, but still, I think most murders, I would bet, have stronger ties to weapons than this one does.
It may be, but, and I guess I don't think that that precludes the court from considering that fact. And I guess I would add to your characterization of appellant's knowledge of the gun that, you know, he knew exactly where it was. He was able to get it. He wasn't just able to get it quickly, but he knew where the gun was in the car. There's no indication that he was searching around in the car for the gun. He was able to grab it right away. So it was either his gun or he had access to it, and he knew ahead of time where it was. But the trial court also had other reasons. So even if the court found that this well-armed element falls under Pope's holding, and therefore it's relevant, which is, I think, what appellant's counsel admitted, that it's relevant, but it just can't be, it can't be the only thing that the trial court can consider. I think that that's consistent with appellant's position. But the trial court here considered other things besides access to the firearm. That was one of the things she considered, but she listed, there were other things. One was the fact that appellant had some sort of, an appellant and his family had an ongoing dispute with the victim here, Baker, and his family. The trial court surmised that that dispute would continue and that if released, appellant would engage in that dispute. She characterized that or called that releasing appellant under those circumstances as adding fuel to the fire. And she had seen the disruptions in court.
Mr. Deal seems to suggest there's not really any evidence or not much evidence that there was a feud after the killing, that this business about disruptions in the courtroom is pretty vague. What evidence is there of a continuing feud?
Well, I think that the court surmised that the disruptions in court, and I mean the trial court, were an indication of a sort of continuing feud. And she was in court, she observed it. While some of her statements on the record are a bit oblique or opaque, I would suggest to the court that it's similar to a credibility determination. The court is sitting there, she's observing the disturbance, she's drawing conclusions about it.
But the difficulty is, if we don't know more about what the disturbance was, it's hard for us to assess whether the conclusions she's drawing are reasonable ones or unreasonable ones. I mean, you know, it would be natural in a setting where someone has been killed and someone has been badly beaten, and so everybody feels aggrieved, that people in the audience might have strong feelings about what's happening. That doesn't necessarily mean there's a feud between them. It just means that there's a lot at stake on both sides and a lot of strong feelings.
But so here you had other evidence that supports the idea of a feud. I mean, you have appellant, you have the relationship between the victim and appellant, and you have appellant going in the victim's house prior to the shootings, wasn't several hours before, it was before the shooting, and confronting people within, looking for the victim. You have the phone calls back and forth. So you have other evidence. And then I would suggest that the trial court is in a position to see this and draw conclusions just like it is when it's making a credibility determination. And when a court makes a credibility determination, this court on appellate review doesn't say, well, the court hasn't indicated what about the witness's demeanor the trial court found compelling. The trial court simply says in some cases that it found a witness, it credited a witness's testimony, or found that testimony convincing, and that's all it needs to say. It doesn't need to give specific reasons.
Can you explain the following to me? I'm not sure I quite understood the trial court's pivot from her first ruling, which is detention is not supported here. A halfway house will do just fine along with GPS monitoring. Then Mr. Gibson gets expelled from the halfway house. She says in the second hearing, I don't want to bootstrap the unavailability of the halfway house into detention. I'm not going to do that, but I am going to detain him. So what changed from the first hearing to the second, except the unavailability of the halfway house?
I think the halfway house was the trial court's preferred way of holding appellant or pretrial status, but when that was no longer available, then the best choice for the trial court was pretrial detention, because that was no longer available, and the court didn't want to release.
That was the only condition standing between freedom and pretrial detention.
Well, she had already, I'm sorry, Judge Fischer, she had already rejected other conditions. When she chose the halfway house, she had rejected, for example, release. She felt release wasn't appropriate, and when that halfway house wasn't available, release still wasn't appropriate. And she felt high-intensity supervision without the halfway house also wasn't appropriate.
So you think, as you understand the trial court's final ruling, if Mr. Gibson filed a motion tomorrow saying, you know, a halfway house is available, so the logic of your most recent ruling is that that's where I should be, you would agree that that would be a fair characterization of the trial court's final ruling?
I think so. That's the way I read it. I read that that was her preferred alternative, and when it was unavailable, her choices were limited, and the choice that she felt best fit the statute and best fit the legal test was pretrial detention, because that was no longer available, that preferred alternative.
The test is no condition or combination of conditions of release will fairly assure so on
The
and so
safety
forth.
of the person.
So
of the community.
you seem to be saying she thought that the only acceptable condition that differentiated between pretrial detention and some form of release was the halfway house.
I think that she thought that the halfway house would achieve the ends of the statute, and that when that was no longer available, that statute's ends were best met by pretrial detention. And that, I mean, that's her holding, that's what she did, and that is the explanation that she gave on the at the hearing during the 20th, and then again on reconsideration. And she gave the reasons that we've all been discussing this morning for that determination.
Was the firearm in this case recovered?
No, not that I'm aware of. It's certainly not part of the preliminary hearing record.
Was there testimony about what kind of a pistol it must have been based upon the shell casings?
I think it's a fair understanding of the hearing record that it was a semi-automatic handgun. The casings were 9mm, and the officer described a little bit about the casings and.
Is there any evidence that this gun was being fired automatically as compared to semi-automatically?
Not that I'm aware of, Your Honor. And the government, I mean, one sort of lurking behind Your Honor's question is appellant's point about shot spotter and other evidence. The government didn't present that at the preliminary hearing, so we simply don't know. So appellant has drawn the conclusion that the rounds must have been fired off very quickly. You don't know one way or the other. You don't necessarily have the inference that they were fired that quickly, as appellant is claiming. You don't have any record evidence about that one way or the other. We know that 10 shots were fired. We know that the casings were recovered. We know where the casings were. There were pictures in the record. We know from the trial court's findings and also from the hearing evidence a little bit about how, not just a little bit, we know how the event unfolded, and by the event I mean the shooting. We know from W2 that appellant got the gun that he shot at both victims, that he hit Baker, he turned and shot at Baker's brother, turned back. The detective said that appellant approached or walked towards, moved towards Baker, and then shot Baker in the head. W2 said that. The detective also testified to that during the hearing. And the detective's testimony, and if you look at the September 14th hearing record at pages about 10 to 13, the detective's testimony sure makes it sound like these are sort of like conscious decisions, that appellant has gone to get the gun from the car, he's come back, he's shot at one victim, he's turned and shot at another, Baker has fallen down, and then appellant has approached Baker and shot Baker in the head. He hasn't just shot him, he shot him in the back.
I heard what you said. You said if we read the detective's testimony, it'll kind of sound like that's what it was?
Well,
as opposed to there being express testimony?
well, let me tell you exactly what I'm referring to. The detective testified that the defendant then went back to the car, retrieved a gun, and shot the decedent. And then later, the detective says, after the fight ended, appellant gets in the car, he gets the gun. W2 testified statement according to the detectives said that W2 saw Baker, the shooting victim, the decedent, appeared to be moving, and then the defendant shot him in the back of the head. And the argument that I'm making now is that the way that the detective testified kind of answers this question that appellant's counsel is making.
The point you're making now, to a degree, could be part of the dangerousness calculation, but it also could go to the first argument that Mr. Deal made, which is that the trial court didn't have an adequate record upon which to find probable cause to believe that second-degree murder while armed had been committed, because the circumstances just don't permit a reasonable conclusion that Mr. Gibson was not acting in the heat of passion. One of Mr. Deal's arguments is that you have not provided this court with any cases that are factually comparable where a court has said it's true that the victim, that the defendant was the victim of a bad beating, and it's true that very quickly thereafter, in a set of shots that there's no evidence was spread out in any way, the defendant ended up shooting people. Nonetheless, it's appropriate to, you can find probable cause, or you can find any, by any sufficient evidence on to sustain a conviction on offenses like, let's say, first-degree murder or second-degree murder that might require a determination that there was no continuing heat of passion. Where would do you agree that you haven't been able to find cases like that, or do you think that you have found them and you disagree with Mr. Deal about how to characterize them?
I think my answer is all of the above, Your Honor. I've got three responses. As to the cases, whether they're factually similar or dissimilar, I think that Williams is similar in certain respects to this case, and I would point the court to that case. In terms of the legal point about the reasonableness of the cooling off period, it does seem clear to me from the cases that there is no minimum or maximum time. There is no required legal time limit for a cooling off period. And the back end of my argument, the third point, is that is a factual point.
Can I just make sure, I'm not sure I really understand what it is that a fact finder is supposed to be determining whether the heat of passion is done, and now we're back into the world of malice, unmitigated, or premeditation deliberation. Does the fact finder have to find, I don't think the defendant was mad anymore, or does the fact finder have to think, although he's mad, his brain isn't so consumed by his anger that he's unable to also start thinking about what he's doing? What do you think it is?
I think it's the latter, and I think the government cites a case in its motion that simply being angry or enraged, very angry, not just simply angry, but being enraged isn't enough to mitigate a murder to manslaughter.
Well, that's certainly true, because you need adequate provocation. So if I got really mad at you and then shot you, I wouldn't have a good provocation defense just because I was angry. But is that a case that is about there was adequate provocation and the court said, well, it's true the person was still mad, but that by itself is not enough?
I thought so. The case is, and I am not recalling the name of the case right now, but it will be obvious in our motion. Yeah, the motion is not. makes this point. And then, so I would say that it's the latter. It's the ability to think reflectively, or the absence of being unreflective.
Well, so, I mean, you don't have to mitigate malice. Well, that's not quite true. Well, yes, you don't have to mitigate malice and therefore reduce secondary murder to manslaughter unless the defendant was able to formulate one of three states of mind: an intent to kill, an intent to inflict serious bodily injury, or conscious disregard of a known risk of death or serious bodily injury. So it's implicit in the idea that you can have heat of passion that will mitigate murder, that it's not, the heat of passion doesn't have to be so intense that the defendant is unable to actually formulate intents or conscious thoughts, because otherwise you wouldn't need mitigation. So it has to be some weird, if you're right, the defendant is still mad, that's not enough for heat of passion caused by adequate provocation. Another is the defendant is cooled down enough that the defendant can formulate thoughts. That's not enough to mean that there's no heat of passion caused by adequate provocation. And then there's some gray area in between where one transitions into the other.
I guess, I mean, I'm not sure exactly where that line is. I'm not sure that I'm being helpful to your, or responsive. I guess in response to your question, I think the third point that I was trying to make is that I think there's a factual answer to this question in this case. So appellant is making an overall legal point about what's reasonable and what's not reasonable in terms of cooling off period. But here you have factual, I would say it's a factual finding by the trial court that appellant had cooled off, that he was acting reflectively.
Where in the record would you point me to where the trial court said, I'm finding as a matter of fact by a preponderance that the defendant cooled off? I thought the trial court said, I am willing to conclude that there's probable cause to believe that, but I'm not really finding it as a matter of fact, and I don't need to find it as a matter of fact.
I guess maybe we're pointing to the same thing, and you're saying, she's simply saying there was probable cause to think this. But when she says, when the trial court says, he wasn't acting under the provocation, and if you give me a moment, I can find the site.
If the trial court found that by a preponderance, then the trial court was logically inconsistent, because the trial court refused to find by substantial probability that Mr. Gibson was guilty of secondary murder. And if the trial court found as a matter of fact that he wasn't acting under the heat of passion, then nothing else was being contested that would have been an impediment to.
Yeah, I see what you're saying. And so your point is that she found by probable cause. She found that by probable cause, or that there was probable cause to believe that.
You can infer the opposite of what you were saying, which is the
Right.
trial court was unwilling to find by a preponderance that in fact Mr. Gibson.
Yeah, I mean, I see your point, and I guess my point, which may not fully answer your point, is that the trial court made factual findings in coming to that conclusion, and they were, I articulated earlier, but that appellant approached the victim. The victims were running away at the time they were shot. Appellant stopped, at least momentarily, to get the gun and come back, and appellant had the wherewithal to approach and shoot Baker, the decedent, in the back of the head, which was a precise shot. Those were things that the trial court identified and spoke about at length in her findings. So I would say that those things were findings that this court would review only for clear error. And I guess your point is more of a legal point, that the overall decision is a probable cause finding and not a finding about those individual facts.
Mr. Smith, go ahead.
Mr. Smith, Mr. Deal referred to a tentative trial date sometime in September of next year. Has there been an indictment returned?
Not yet.
Not yet.
No, Your
Okay.
Honor. No.
Can you shed any light on this legal question? In 2009, the council amended section 1322 to say that a finding of probable cause, as distinguished from substantial probability, is enough to trigger a rebuttable presumption of dangerousness. As a general matter, the crimes covered by 1322 are a lot less dangerous than what we have under 1325. Do you know why they didn't amend 1325?
To reflect the same, I don't know the answer to that question, Your Honor.
To allow a rebuttable presumption be triggered by probable cause?
I don't know the answer to that question. And I agree, and the court's colloquy earlier reflects this, that it is an oddity between the two, between 1322 and 1325.
I
Facie legislative oversight?
I would, yeah, I haven't really explored that. The parties haven't briefed it, so I don't know whether that was an oversight or really don't know.
It appears that there are offenses that occurred here that could be covered by 1322, which would trigger a rebuttable presumption of dangerousness. The problem would be you'd have to get to trial pretty quickly.
Yeah, I would agree with that, and that's why the government didn't, at least in part, why the government didn't seek a 1322 hold, and didn't ask for it below, hasn't asked for it on appeal. But
If I understand it too, you have not asked us to remand for further findings, is that correct?
we haven't, although I think that may be available to the court. We didn't ask the court to do that in our motion.
I hear a period of silence. Do you have
Okay.
anything else you want to say?
No, if there are no further questions, we urge the court to affirm the judgment of the Superior Court. Thank you very much.
Thank you. Mr. Deal.
Thank you, Your Honors. I realize I'm out of time, so I'll try to keep it brief. I want to address 3 points, one on the voluntary manslaughter issue, 2 on the Pope issue. On the voluntary manslaughter issue, I just wanted to address Judge McLeese's question about sort of how to conceive of the difference between acting with a cool mind versus with calm reflection. And I would just point you to 2 sites that I think are somewhat helpful in thinking about it, and that's Comer 584 A2D 2645 note 24. And it just says that voluntary manslaughter is a killing committed with a design to kill. So I mean that's the intentionality part of it. Under the influence of a sudden and violent passion caused by great provocation. That might not be that illuminating, so let me give you a second one just in case.
Probably not literally accurate either, because voluntary manslaughter can be predicated on
Sure.
conscious disregard of a known and substantial risk of death or serious bodily
Of
injury.
course.
So it's a little imprecise.
Of course, one of the 4 possible mens reas for purposes of this case, it's pretty precise because design to kill is at least in the case. And I also wanted to point to Carter versus State, 66 Maryland App 567 at page. So this is from 1986. And what they said in that case, it was 60 to 90 seconds was a short elapse of time that it could hardly be deemed sufficient as a matter of law. And it says for a hot-blooded passion to subside and allow for cool deliberation. I mean, just as far as conceptualizing it, I think it's, can you say that there's enough time for hot-blooded passion, given the degree of the provocation, to cool, to allow for calm and cool reflection? I think that's just conceptually how I would think about those issues. I want to address
Can
one
you
of
just make sure, is the issue whether there was enough time or whether in fact that's what happened? I mean, so let's say someone does something that enrages me and is adequate provocation. And I am a bad-tempered person, and although most people would calm down in a week, I have tons of evidence that I just walked around in a rage for a week, and all I did was just mutter and scream and yell, and then I eventually took action. Would you say if in fact I didn't calm down and I just never...
No, I would not say that.
So...
The provocation needs to be such that a reasonable person's reflection would be stilled for the period of time that we're talking about. If you're that's all the courts that I'm aware of use a reasonable person standard, and you look at the provocation, you see how long a reasonable person's reflection might have been stilled, and I don't think that's an abstraction we need to get into this case after the death threat and body slam and violent beating. That, like I said, I can't...
If that's right, is this a fair way of characterizing the issue for the trial court? Taken as a given the provocation that your client suffered, could the trial court find probable cause to believe that his reaction was unreasonable, notwithstanding that provocation? And if the answer to that is yes, then it could be a second-degree murder charge, and if not, then not. Is that a fair description? Because
No, maybe I misheard you, but let's be clear. The reaction doesn't need to be reasonable. The rage needs to be reasonable. And then the action that follows from the rage can be perfectly unreasonable. I mean, if it's a perfectly reasonable reaction, you're just in self-defense territory. We don't get into voluntary manslaughter. The question is whether or not the rage and incitement is something that a reasonable man would feel for, you know, a few seconds in this case, maybe a few minutes in some cases, maybe longer in some
That's a fair
cases.
point, although I think you agree, though this case does not seem to present it, that there may also be a separate question about whether there is a disproportion between the action that is taken during the period of rage and the provocation, so that if, I don't know, if in a case like this, the defendant, instead of firing off some rounds, had, I don't know, shot a gas tanker that blew up, you know, they're standing next to a school bus with lots of children, you might think, I don't care how mad you are, that's just a disproportionate response. That might be a possible set of issues too, but not raised by this case. Is that
That's definitely true. I mean, the cases that tend to raise whether or not provocation, you know, you're usually talking about insults and the mere words, or somebody who like poses a minor threat to you. Once you have a quarrel of this degree, you know, the cases don't even talk about whether or not a killing, which is what we're talking about here, is proportionate in that sense. I do also want to address Judge Fisher's question on the amendment to 1322 that wasn't accompanied by an amendment to 1325. I think it's a very interesting question, and all I can say is I think the legislature wanted to put a thumb on the scale in favor of detention when you're talking about 100-day holds, because they're quick and they're brief, and the liberty interests aren't nearly what they are under a 1325 hold where you have indefinite detention.
I vote for the explanation. They didn't think about it, but
That's
we'll never
possible
know.
too. I try to read legislation as if it's all very thoughtful and well put together. And
That might be a mistake.
the final thing I want to say is when the government got to the other factors outside of the facts of this case, all they kept saying was the trial court surmised there was a family feud. The trial court surmised there was a family feud. The trial court, in its own words, says there appeared to be two families continue to engage each other, and that's September 20th, 26. And all I can say is, you know, their own words, the trial court's own words, tell you that this is just a guess. You know, you're talking about people in a courtroom who are making outbursts. You don't have any facts for the record that you could defer to, that there's any threat from Mr. Gibson or his family, or even that there's any threat from Mr. Baker and his family. All you have is some courtroom disruptions that are extremely minor on the record that the court has. So for those reasons, we'd ask you to reverse the detention order that the trial court issued. Thank you.
Thank you, Mr. Deal. Thank you, Mr. Smith. The case will be submitted and the court will stand adjourned.
All rise. This court is now adjourned.